Okay then, so welcome to this week's webinar, GDPR, when IT meets legal. Today we're pleased to welcome our GDPR legal partner, James Haddleton of Haddleton Legal, and Connexica's pre-sales consultant, Chris Lewis. Today's session will last around 45 minutes, and we'd love to hear from our listeners. So feel free to ask questions in the chat as we go along, and James and Chris will answer your questions at the end of today's session. Everybody who attends today's webinar will receive a copy of Haddleton Legal's GDPR Mythbusters fact sheet and also Connexica's GDPR Data Discovery Management Solution. So what does the next 45 minutes look like? In a moment, we will hear from James and Chris, who will talk a bit about their backgrounds and the work they're currently doing. We will then have our first of two polls, which we would love you to take part in. James will open today's discussion by talking about GDPR, what your organisation needs to be doing, common pitfalls organisations often face, plus much more. We will then have our second poll, followed by our own Chris Lewis, who will discuss what you should do for a data audit, what you can do with your information asset register, and ways you can speed up the compliance process. To end today's webinar, James and Chris will answer your questions. If we are unable to answer any of your questions in the time we have, we will follow up with you after today's event. So, hi James and Chris, welcome today. Thank you for participating in today's webinar. Would you please both like to introduce yourselves and tell us a bit more about your backgrounds?
Certainly. I'm James Haddleton, and I'm a solicitor. I was a partner for many years in some large law firms. Most recently, I was Group Legal Counsel and Company Secretary at Clinigen Group PLC, which is an AIM-listed pharmaceutical company, and there I implemented GDPR. At present with Haddleton Legal, I advise on audit implementation for GDPR.
Perfect.
Awesome. My name's Chris Lewis. I'm the pre-sales consultant at Connexica. I'm largely focused on engaging with new clients and partners, and I've had an active role in both our internal GDPR compliance process, the design of our own GDPR solution, and then marketing that to the wider world. So there we go.
Perfect. Thank you. So we're now just going to jump into our first poll. So if you would all like to take part, that would be wonderful. So the first question we would like to ask is, are you ready for May 25th? So James, in your experience, yes. How are you finding people and organisations that you're working with? Are they prepared for May 25th on the whole?
It's a very mixed picture. I've got organisations which are large and one would expect to be ready by now, who haven't started their data audits getting ready. I am working with a small charity which has been ready probably now for almost a year. So it is a very mixed picture.
I think people don't really understand what ready exactly means, because there's still quite a few grey areas, either within the legislation or from the different advice. When you go on LinkedIn, you read to the every different GDPR expert will have a different opinion about the same sort of things. So really, there's a whole lot of not unknown about what readiness really even means.
I think that comes to a really important point, which is that nobody's ever going to be completely ready by the 25th of May. This is about risk management. It's not about counsel of perfection and having everything done by the 25th of May. The analogy that we brought to it, particularly at Clinigen Group, was health and safety. You manage that risk on an ongoing basis. There are things you will do now to get policies corrected, contracts remediated, but nobody will be ready by the 25th of May.
I just remember there's, I mean, from the conversations I've had with the clients about every type of story, the one that always sticks to mind is the organisation that said, right, we're going to go to a board meeting, we're going to decide what we're going to do about GDPR. And they came back to me after they had their board meeting and said, well, at the board meeting we decided that we didn't really comply with the Data Protection Act anyway, so why would we bother with GDPR? I think, I mean, that's one angle that I'd perhaps not recommend.
Well, there was a survey by a London law firm that suggested 55% of small businesses have not even heard of GDPR. But I think we're all aware of cases where, even under the current legislation, TalkTalk being the most obvious one, companies have been fined a lot of money. And individuals, there was a charity worker in Rochdale who sent work to his home email address one evening to work on. He was prosecuted successfully, lost his job as a magistrate and in the charity. So that's under current legislation, but it will obviously happen.
And I seem to remember he was trying to act in the best interest, wasn't he? I don't think he knew he was breaking the rules, or was not aware how flagrantly he was breaking the rules.
No, I think that's right. I think it's a risk. I mean, one of the things we talk about tips here, but one of the things we're saying is clearly don't use home email addresses, don't use personal mobiles for work purposes, and get rid of autofill on email. How many times have we all sent an email to the wrong address? Send that with personal data, especially sensitive personal data, which is what this Rochdale charity worker had, and consequences are there to see.
Perfect. Right, I'm just going to close the voting on this poll, and then I can share the results. So there we go. So the results in shows that 35% of people polled today, they say that there is a solid plan in place to ensure we are prepared for May 25th. And around 10% of the audience are saying that we just don't know where to start. So quite an interesting mixed bag there. So thank you everybody for taking part.
Well, I hope we can give you some pointers to that 10% today on where to start. And I'm sure the waiting for the guidelines, I think we all are, and we'd all like to have a bit more clarity. And it's a case of doing the best we can for now, isn't it?
It is. I mean, it is worth saying that the draft bill, there are only certain aspects of that draft bill which will change the fundamental regulation, the GDPR. For example, the age of minors, whether it's 13 or 16, it's those sort of things that the bill will decide. But without the bill, the GDPR will still become law and or be enforced, I should say, after the 25th of May. So understand the need for guidelines, but there are things that we can do knowing that this will become law.
Perfect. Okay. So we're now going to hand over to James, who is going to talk to us in a bit more detail about GDPR.
So I think the first question to ask is what practically can you do to prepare for the new laws? Again, I come back to my first point that you're not going to be able to do everything by the 25th of May. How it would look holistically is that you would prepare your audit. Effectively, you are looking at what personal data you get into your organization. You're looking at where that goes, both internally and externally, and that maps out your data flow. The reason for doing that is that will start to show where you need to make changes. At the end of that audit, I would expect that there are a number of things which need to be done. For example, privacy policies, document retention policies, home working policies, document usage policies, computer usage policies will need to be updated. I think also contracts with external bodies will need updating. For example, where you use an outsourced company, certain clauses which must go in those contracts where that outsourced company processes data. So, for example, a outsourced payroll company or an outsourced IT company, clauses must go in to the remediated contract, preferably by the 25th of May. But the ICO has made very clear that she is not there to, the Information Commissioner, Elizabeth Denham, that she's not there to punish people with these massive fines. She's a whole host, I think 10 other measures that she can take, and we are expecting most of those to be advisory where she does intervene.
Just to quickly interrupt there, James, and add to that, I'd recommend, especially to those 10% who don't know where to start, that reading Elizabeth Denham's blog is a very good place to start. It's very informative. She speaks in a very clear and understandable language to people that aren't clued up on data security, and I'd really recommend reading that blog.
I'd endorse that. And in fact, the ICO's website has some very useful and well-written information. There's probably quite a lot there, but it is accessible to people to read. I think if you're looking at what's the minimum to get away with by the 25th of May, then it really is the data audit, getting an understanding of what your data is and where it's flowing within the organization. How it will affect different entities is going to be dependent on what the focus of that entity's business is. In terms of the marketing department, that is clearly going to be requiring its people to get consent, a positive opt-in from people that it's marketing to. Where marketing touches on sales, you'll be looking for people to get rid of those little notes that they make when they go and see people, such as Jim has broken his leg. That shouldn't be captured anymore. It's not necessary for the business. For employees, you'll be looking to be clear about how you use their data. Where you have office photos, that will need their consent. You need to be very clear when you've got sensitive personal data about health issues. You need to be clear with those people how that will be used. That's not a problem. It just needs to be made clear to those people. One of the principles is transparency, and that's the box that's being ticked there.
I was reading a good example only on LinkedIn yesterday around maternity leave. Right. So if an individual in your organisation goes off on maternity leave, how you should not disclose that they are on maternity leave. You just have to say that they are on leave, because if you're disclosing they're on maternity leave, then you might be conveying information about their health, which would be, special category data. It's one of those sort of edge cases that probably don't really matter that much in the wider scheme of things, but it's an interesting way of looking at how we might need to approach things slightly differently.
Yeah, that is an interesting one. There is a debate out there about amending contracts to get people to give consent, employees to give consent to how their data is used in certain circumstances. There is an imbalance between the employer and the employee in terms of their relationship. So whether you can truly rely on that consent is another debate. But if we look at this from a risk perspective, of managing risk, getting consent in a contract is a good way of managing that risk, even if it's not watertight. Like all risks, it's not going to be perfect. You just have to manage it as best you can. I think in terms of IT, I'm going to sort of suggest that Chris is probably a better place than me to comment on that.
Well, the main thing that GDPR impacts on IT is that you've got to make sure that we have a lockdown on our applications and what we're using them for, and make sure that we don't keep things unnecessarily. I think up until GDPR, there's been no need to remove old and outdated information. As a result, we can have data warehouses that stretch back for 15, 20 years with historical information. We've only been keeping it because in case it might be useful for analysis or something like that. Whereas now, you need to have a clear legal reason to keep that data, especially if it's personally identifiable. Well, entirely if it's personally identifiable. So I think that's transforming the way that IT organisations are having to process and understand the data within the company, and then how they then disclose that to and from third parties and all the collaborative working they might do.
And I think just on something that's come to my mind in terms of marketing, but it links across with IT, is be wary of things like MailChimp, where the servers are hosted in the USA. Most of you will use, for example, Adobe. Again, they may well capture information. I'm not for one moment suggesting that you can write to these people and ask them to change their ways, because they are looking at GDPR, and you will be hearing from those organizations in due course. I've just heard from Microsoft as to how they will use data, but really important to know where your data is, where the servers are, particularly if they're outside of it, which is effectively EU plus Liechtenstein, Switzerland and Norway.
Just to add to that as well, Dropbox is a good example. Dropbox have some servers within the EU, Dublin servers, but you're only allowed to, or you only get given one of them or allocated a Dublin server if you have over 300 accounts or different users with Dropbox within your organisation. So a lot of they might advocate that they're within Europe, but when you actually read the terms, your data might not be held within Europe. It might be held in the USA, unless you are of a certain size. So I know for a lot of SMEs, especially like ourselves, that's a concern, because we use cloud file servers to try and collaboratively work across our organisation, and we only have 30 to 40 employees. Got to imagine when you've got hundreds of people, what other way can you use to cross-work across multiple computers and workstations?
Yes, and I mean that raises another point about the United States. Those who have technical knowledge will know that there's an agreement in place between Europe and the United States called the Privacy Shield. In essence, that is a guarantee, if you like, of the security of that data. Security of data is only one of the data protection obligations under the GDPR, and it doesn't stop other obligations such as the data processors obligations. which, as I mentioned earlier, need to go in a contract between the person who controls that information and the data processor. That needs to be in place as well with the US company.
But we're not stopping to put your files in Dropbox, are we?
No, we're not. Again, it's about risk management, and the ICO has made very clear it is not trying to stop business. So I think we have to take some of the headlines about big fines with a large dose of salt. But just moving on, just looking at some of the pitfalls, I think the biggest pitfall that I've seen is that it's relatively easy to change policies, amend contracts. It is resource intensive, but the biggest area of concern is around human error and culture change. So it's all very well putting these policies in place. You do need to get your people on board. Organizations like law firms, which I'm helping, and health authorities, they've had a long history of compliance. So perhaps the cultural shift will not be so great. But for others, this might be quite a shift in how their people deal with data. And of course, people come in and go out of companies. So there needs to be a constant program of training on these matters.
I guess a common pitfall will be not taking it seriously enough and not doing anything about it. I think that's
we've got people who've rung in and said, companies that have said, oh, we hear we're exempt. They're not. They're ordinary companies. I go back to that survey by another law firm in London. 55% small companies don't think that it applies or don't know about it even. So doing nothing is not an option really on this at all. Just to say, those who are DPA compliant, that's the Data Protection Act 1998, we're saying that probably a 25 to 30% uplift on that is about what to expect for GDPR compliance. Finally on that, just how do I make my contracts compliant? You will need at some point to audit those contracts, to look at those clauses which talk about information transfers. That was particularly relevant in healthcare pharmaceuticals where I worked previously. You've got to make sure that those terms are right. And as I say, in relation to data processors, their obligations to follow the instructions of the data controller and to report any breaches, that needs to be put into a contract as well, a written contract as well.
Yeah, so I mean, I know that you spent a large amount of time going through contracts yourself with your clients. I mean, is it a particularly resource intensive job?
It is resource intensive. I would suggest that those with large numbers of contracts, you do need something to AI or some data analytics tool to search those so that you can ignore those contracts where it's not necessary and focus on those contracts where it is necessary to make changes. Otherwise, you're just relying on humans going through contracts and finding nothing in some and something in others.
And we all know that, well, the people can make the biggest, the hardest thing to control, isn't
it? That's exactly right, which goes back to the issue about training.
Yeah.
Perfect. Well, thank you for that, James. We're now just going to jump straight into our next poll. So the next poll is, have you completed a data audit yet for GDPR?
Okay, well, I guess
probably kind of your area, Chris, a bit more.
From our perspective, we did it at the turn of the year, and that's how we started focusing largely on GDPR as a use case for our own software. But yeah, the amount of times, and even just in our company, finding Excel spreadsheets where somebody's got it, they sent it across to somebody else, they've put their own initial on it and made a few changes and sent it back, and then you end up with these constant duplicates and unnecessary copies of information. They're so quick to find stuff like that and realise how much work needs to be done to make sure you clean up all this data. You know, we could be talking on gigabytes of data, or even terabytes of data. I know that with a couple of the clients that we've worked with for GDPR, we point our tool to an up to 30 to 35 terabyte Google Drive, for example, or shared drive. And then you can only imagine the amount of duplication, the amount of erroneous information that you can find in there. You search for a certain individual's name, it might come up there hundreds of times or thousands of times across similar documents. So I think data audit and understanding where that all is definitely the first step that you need to take. Otherwise, well, how can you protect what you don't know?
And I know you refer to it as a data inventory because you can sort of see the value in having knowing what your data is.
Yes.
That's useful in itself, isn't it?
Oh yes, mentioning Elizabeth Denham, it's one of the recommended ICO things that you produce after this audit is that data inventory and all the things alongside it, like data processing records that I'll go into when I do my bit. How are we doing for the poll?
I think we're just going to go and close the poll now, and we shall share the results. So there we go. So we've got around 10% of today's poll that they've not yet started. The great thing is that everybody does know what a data audit is, which is always very positive. Here, and yeah, as we can see, 44% say that the data audit is in progress and is on track to be ready before May 25th. Great to hear that.
It's good news. And I think, again, we said as the minimum, get the data audit done. So it looks as though nearly half are on track.
Perfect.
Well, and we've completed it, which is great. So
really?
11% have completed.
Yes,
we have our 11% who've not started yet, which might
congratulations.
The same individuals who are just approaching GDPR for the first time.
Perfect. Okay then. So we're now going to hand over to Chris, who is going to talk to us about GDPR and the fact that it is not just a tick box exercise.
Yes. So I mean, this is the constant, the thing that we've come across quite a lot is around putting a tick in a box and trying to do this one-off. GDPR's ready, 25th, right? Let's go. Carry on in the future. And obviously, from our perspective, we don't think that's enough. We think that when May 26th comes around, maybe a new employee joins the company, we get a new application, or we're doing a new business process with data that we're already holding. That data can quite quickly duplicate and quite quickly become outdated, and without maintaining that and constantly re-auditing, you're going to quite quickly start spiraling out and no longer having control of that data. My first one is, why should I look at conducting it? Well, partly because the ICO tell you to, and partly because it's quite a useful thing to do. How do you know what you're protecting if you don't know what data you have? And if you don't do a sort of deep dive data audit and just say, well, this contains email addresses, well, that's not really enough, because if that's those individuals maybe have the risk to have the right to restrict processing of that data, or maybe there's some other reason to why you shouldn't have that individual's data. If you don't know where that data is, you just say, oh, well, there's email addresses here, oh, well, there's names here. Well, I don't really think that's enough.
But I think, Chris, is it not also true to say you can focus that audit search so you don't have to look at things manually that you might otherwise if you've got good data analytics looking in at it?
Oh, yes.
That's what I found on mine anyway.
By using a technical solution, I mean, you can use a lot of the manual processes rather than focusing on just doing it manually and looking at
you don't get rid of the manual process, do you? Yeah. You reduce it substantially. I think that's the point.
Yeah. I think what you really want to do with the data audit is understand the flow of data through the organisation, so where it comes in, where it leaves, where your most high risk areas are, which employees or maybe information asset owners have the highest risk data within their own workspaces, and what controls do we have over that data to make sure that nothing happens, or that we can keep control of what our employees are doing with the data. And that should all be the outputs that are generated by this data audit. Will help you understand the flow of that data and what you're actually doing with it. It also contributes to the other necessary outputs that the ICO recommends, which includes, as I've just mentioned, the data mapping exercise, any data privacy impact assessments you might need to undertake on data. For those that don't know, obviously, a risk assessment on where a data process might impact the freedoms of the individuals involved within that data process. That's another thing mandated by the ICO, and they've got some very thorough and comprehensive guidelines on when to do a DPIA and when not. Often it's when you're maybe buying a new software application or you're establishing a data process that focuses on sensitive data or things like that. Correct me if I'm wrong, James.
No.
And then also, as a result of doing the data audit, you should also then start to generate and work towards the data processing records. I know that's a big thing that people are worried about, is having to write down everything that they're doing all the time. Well, it's not really like that. You don't have to just constantly be updating and spend all your time doing paperwork. I mean, and again, if you use some of the solutions that are out there that can help you sort of create these records as a part of doing the audit rather than having it as a separate activity.
I definitely agree with that. I think it is important to emphasise that record keeping is as important as the decision you come to. If we talk about risk management again, the ICO will be able to and will want to see the process by which you came to that decision, which is not dissimilar from, as I say, health and safety or other risks that businesses manage.
So finally, also, it's identifying our information asset owners in the business. I know it's a simple thing, and I've been to one of our clients where they were talking about lots of people wanted to be the information asset owner because they had to put a team there because they thought it was always my data or I'm important or whatever it might be. But in the end, it's good to identify who these individuals or indeed teams of individuals are in the organisation, so they can make sure the appropriate training and policies and procedures are in place.
Yes. Just on that, we're sort of advising that you have your head of department over particular data that's found. So there is accountability and responsibility for improving that data.
And if a breach happens in that data, you can start to talk to about why this might have happened. So that's my first bullet point. The second one, so what are the benefits of a data audit and how will it help me in the future? Well, I really do think that, I know it's a lot of people are seeing it as a laborious exercise that don't really want to do, but there are some benefits that it generates as well. It's going to increase your data quality across the organisation by helping you get rid of your misspelt, erroneous and outdated data and allow you to, whenever you're making a business decision, you can pivot on information that you now trust, information that you've done a comprehensive audit process on. So if you have any reports, you can have transparency to understand where these reports have come from, where these decisions have come from, who these leads are, and why I know them, and what these accounts are, and what these people's preferences are, my customers. All the most important things for making business decisions that aren't going to upset your customers or your clients or the citizens if you're the public sector, or patients or whatever it might be.
Yeah, I think it's a confidence building measure as well. If you've got cleansed data, you can be fairly certain that you're A, not wasting time, but B, your customers, those dealing with you, can be confident that you are treating their data correctly. You've got processes and the accurate data there.
And that's also another reason why I think that if you keep doing that data audit and have a sort of automated process which you can customize and post May 25th, it really helps you then keep that level of cleanliness and keep that level of data quality. So it's not going to start slipping, because we all know that you do the best will in the world to establish a process and a policy, but to make people do it is always the hardest point. And we can do training and we can have refresher courses. It's also good to have something automated there as well. If the computer says no, computer's always going to say no for the same reasons, because that's that you can set up the reasons for why it's doing that. And sometimes a very straightforward yes or no can be make an organisation realise that something might be going wrong.
Yeah, and if we just take a very simple example, by May the 25th this year, it might be perfectly fine to keep somebody's details on file like a CV. By May the 25th next year, a year might be too long, and that data should have gone. So I definitely agree with the ongoing risk management of that through both manual and automated process.
Number 3, I've got, do I have to remove all my PII if I don't have consent for that data? It's a common sort of, let's say PII, also personal sensitive data. PII is more of an Americanism, but it generally means the same thing. Personally, could be a name and address. PII being that name and address together to identify the individual is a very one way of describing it. You don't need consent to keep all your data. And I've heard a lot of people talking about consent like you absolutely have to have consent. I know that's incorrect, and know that you can give some advice on that, James. And where, because in the end there are 5 other different legal bases for processing data if it's personal.
There are.
And consent is just a tip of the iceberg.
No, Chris is absolutely correct. There are 6 bases. I think the 2 which affect most people, I know people have their views, but consent and legitimate business interest. And I think it's worth saying that, for example, if you have people's personal data for, let's say, the purpose of payroll, that is a legitimate interest, and you don't need to seek consent. Consent has its benefits in that, of course, you've got that person's consent to deal with the data in the way in which you said you will. The difficulty with that is that consent can easily be withdrawn. So on the whole, legitimate business interest which is a balance between the interest of the business and the interest of the individual. That is the better way to proceed. You don't need consent to all uses of personal data.
I think that's where the advice comes in, because in the end, legitimate business interest is very much lawyer speak than everyday layman speak, and I think that's where get confused, start to worry, I'll do an e-consent for everything because they don't understand what the other 5 are.
Yeah. I take no responsibility.
Okay, right. Yes. Data, which is either supervisation or maybe some other acts that's mandated within the legislation of a way to bring the data out of the scope for GDPR. You can still then retain it and use it for analysis.
Yes. If you, for example, get consent to use somebody's data for marketing, and then you decide to do anonymized data analytics, that would be fine. The problem occurs if you can actually work backwards again to identifying somebody. So it must be genuinely anonymized.
Well, that's to do all around the quality of the obfuscation techniques that you employ. I think not just encrypting names and addresses, but also utilising things like small numbers. So if somebody's got, we work like in the NHS, and the example is if somebody has an obscure medical condition, there might only be 3 or 4 people that have that condition. So even if you get rid of their name, their NHS number, and their address, you still might know who they are. So being able to mask things like that helps bring that out scope and ensure their privacy.
Yes.
So I've got as number 4, what do I do with my information asset register? Well, this should be the main output from our data audit, is an information asset register, and that can either be a spreadsheet or it could be an interactive piece of software. And what that's going to do is help you understand where you need to allocate your risk and where you need to best allocate your resources to become GDPR compliant. Also, you need to identify who your information asset owners are, what types of data are held where, and what data processes do you have on a data source by data source basis. From this, we should be able to quickly identify which data processes we need to carry on using and which ones we don't, where we might have that outdated or erroneous data, and all the other things that we need to do to make sure that data becomes compliant. Yes.
One interesting one yesterday was travel and people receiving passports for the benefit of travel. The company had requested passports as a matter of course. In fact, they didn't need to. There are very few airlines that require it up front for various reasons. I think Ryanair is one. But it's looking at the processes and actually deciding whether you need to take personal data, because you can only take it if it's necessary.
Oh yes, certainly. And in the end, the more data that you take, and the more control it's going to have, and the less agile you're going to be able to pivot when you've got that data within your systems.
Actually, another one, just briefly, sorry, Chris, is the training department. So if you use outsourced training providers, you'll get a host of different requirements from them as to what data they want of those attending, and clearly that is something that should be standardised. I can't think beyond name, address, and perhaps title, unless it's a particularly specific course.
Okay, I think Jenny's trying to get me to move on, so I'll quickly run through the last one. Should I be using software? Well, obviously we think yes. We think that you can automate many of the processes that you would have to do manually, and that includes everything from doing the initial data audit, identifying within each data source who the information is in there, what types and what the veracity of that data is, understanding which data is out of date, automatically identifying duplicate documents, automatically being able to then create lists of these things where we need to tell the information asset owner we need to do something about this. Creating things like block lists, so if somebody does say they want to have their data, restrict processing of their data or remove their data, making sure that if their data comes back in, that we get rid of it, or we make sure that we don't bring it into our system, and that we're alerted. Finally, getting rid of things like data duplication and all the other things that I've already mentioned. If you use software to do that, to help you automate both the discovery and the removal of those things, it's going to make it a hell of a lot easier for you to do your job.
Just on that, I think if you look at it this way, if you've got cleansed data, if you can then plug an application on that cleansed data, so that when you get a subject access request, you just type in that person's details and it plugs into that cleansed data. It is a really useful use of IT data analytics to help you. And obviously, you've only got 30 days to comply if you're doing that with a request. If you're doing that manually, that's quite a task. when you think of the thousands of emails that probably exist.
Finally, and then software, just a quarter of the jigsaw. There's the whole people, products, processes, and policies. So we're all talking about products with software, but in the end, 1 quarter is a quarter less that you need to worry about.
Yeah.
And it gives you a lot more time to focus on the real difficult thing, which is convincing people to change the way they're working and enforcing the policies that you're going to put onto those people.
Perfect. Yeah. Thank you very much. Just conscious of time because we want to answer as many questions as we can. Please keep your questions coming in to us. Just going to jump into the first question here. It's probably one for you, James. Please, could you explain a bit more around what legitimate interest is and how it affects kind of B2B organisations?
So legitimate interest, just expanding on what I said earlier, is a test to check whether your interests outweigh those of the individual. It is the business route to using personal data without consent. I've mentioned payroll as an example. You might use it for other purposes, for travel, for example. You might need it for travel. I think it's the way in which how I would describe it is getting past the hysteria of, oh goodness me, we can't do anything with personal data. Legitimate business interest is the one that says you very definitely can. So you've got that test to weigh up the interests, but where it's clear, like payroll, it should be a fairly easy decision to make.
Thank you. I've got another question that's come in here. It's quite topical actually at the moment. What do you think about the Cambridge Analytica article which has come out this week, obviously especially in regards to GDPR?
Well, obviously I wrote, I don't know if you've seen, but I wrote a short piece myself on LinkedIn yesterday about it. So it's just it's what we've all suspected for a very long time, in that people have been using our data for that. Reality of it is even supposedly and allegedly to a much greater extent than we even anticipated. It's quite amazing, I think, when you watch that video about the guy saying that what we like to do is record them and mask the person's face whilst being recorded and have his face masked. I thought that was a nice bit of irony there. But I guess it just shows the importance of data security and what can happen if you don't keep that data secure.
It does. I mean, under the GDPR, so if you have, say, your employees' data and you push that out to a payroll company, not only should you have those contractual provisions in place now, but you're also supposed to audit regularly. So if you look at it from a perspective, yes, they say that the academic wrongly sold or passed on the information to Cambridge Analytica. But by the same token, what were their measures, would say under the GDPR, to ensure that he was complying with the contract, that this wasn't happening? That might be a difference of approach that you'll see. People will be following up what people are doing with the data.
Do you think Zuckerberg will testify before the House of Commons?
No, I think he'll stay safely over there in the States. I would if I were him. But I mean, it is interesting because listening to the professor on Radio 4 this morning, he was making it very clear that he didn't gain personally from this at all. He was doing a sort of psychological profiling, and he seems, although he denies it, to have got it wrong from a Facebook perspective. But he also seems to have been taken for a ride by Cambridge Analytica. Of course, unfortunately for him, ignorance of the law is no defence, if that's where he's going. So again, we can't be complacent as we move beyond the 25th of May. We're going to have to be making sure that we know what is being done with the personal data that we control.
And I mean, we're all gonna want to send a DSARV off to Facebook and understand what they know about us, but I feel at the same time they're gonna not really answer it correctly. I don't think. And
smugly, I'm not on Facebook, but that's probably a reflection of age than anything else.
I don't think I'll be on it for particularly much longer, James, if you ask me.
Okay, the next question, which comes in for James. So this member says, really appreciate this session, so we're glad to hear you're enjoying it. I keep on being asked about CVs being sent to recruiters, therefore being stored in emails, desktops, PCs of recruiters, and even on cell phones, and all of this speculative resumes. And this member has even said that they themselves have sent over around 100 CVs. So how does this kind of, for an organisation, how should they be operating with CVs? And
so very briefly, what I would suggest is, in the first instance, one of the principles is transparency. So you should be saying to those individuals whose details you're taking, what you're doing with their information, preferably gaining consent, but it's probably part of their expectation. So perhaps legitimate business interest. But anyway, get there, at least make them aware of what's happening. Also, those organizations you send it to, you're sending out personal data. You should be making sure that they are acting on that in a particular way. So you might ask them to destroy it after 6 months, because CVs tend to become unviable after a short period of time. So you yourself should be getting, or considering getting rid of CVs after a period of time when they've either got the job and moved on, or they decided to do something else. And you should be also saying to those companies to whom you've sent CVs, you ought to be deleting it after a certain point to ensure.
Is telling them enough, or do you need sort of legal arrangements, or is it just
yes,
email, you must
yeah.
delete this email? Is that enough?
No, you should have your terms and conditions with those that you are operating with. You're absolutely right, Chris, for picking me up on that, making clear what they can and can't do with that personal data. And that might include simple things like you're not allowed to circulate that around the organisation saying, oh, here's an interesting CV, might this be of interest? You need to have something, perhaps a better process than that, to ensure only the right people, the necessary people, are seeing that personal data.
Perfect. I think we've got time for one more, and this is, what is your advice on cookies? Currently, cookies are installed, and notice says the onus is on the user to disable cookies in their browser. Even ICO.org.uk does this. So where do we kind of stand on cookies?
Well, I think that's still it's a grey area in my mind. I mean, I know that the websites just act differently if you disable cookies. Some of them just boot you off if you're saying that I do not consent, whereas some of them will look like they'll work, then you click on something, then it won't do anything. And I couldn't tell you what the best way to approach this is. I just think as long as you have a very clear policy in place that and tells the end user what these cookies are going to do, and in the end, if it won't operate without cookies, the website won't work, then you just have to tell them that.
I agree.
And that's it.
Very, very briefly, I would just say, again, take a risk management approach to this, risk-based approach. If you need them for your business, just make sure you're being transparent. You've got your cookie policy up to date. It's accurate, and then people can make their own choices. I agree with the ICO, and again, it's not trying to stop business. That's important.
So we've not answered all the questions, but I think we're running out of time, aren't we?
Will we have time for this last one?
Yes, let's quickly ask this last question. If you're varying contracts to include data processing clauses, are you able to send out standard terms which will not require the signature of the other parties, or does the agreement have to be signed by the other party? If you need a signature, does it mean the new terms are not binding on the other party? So, two aspects. One is that the processor has direct obligations, if you like, enforced by the Information Commissioner, which are in fact a mirror of those that will go in the contract between the data controller and processor. So the processor doesn't get out of it, if you like, in a regulatory sense. It's going to depend on what each contract says, but my advice at the very minimum is to send those to the other side, to the processor, to say to them, either reference a written contract and say, pursuant to this clause which allows us to vary it, here are the new terms which you have to abide by, and unless the clause actually requires a written signature, then there are other ways of showing consent, such as an email back saying, yeah, that's fine. Depends a little bit on the type of document, but in essence, the risk-based approach is to send those out to the processor. That is a good start, even if they don't come back to you.
Perfect. Well, thank you very much. Thank you for your time today, Chris and James. That is unfortunately the end of today's session. We hope that you all found this interesting. For me, the biggest takeaway really has to be that it's not too late to start. Don't be scared or put off starting to prepare for GDPR. All organisations will be affected, and as a minimum, it's important that you seek out advice and information data audit. Definitely something that we've touched upon is that it is really worthwhile investing in the right software and the right advice now to reduce any future potential costs and penalties. I think that just leaves it for me to say on behalf of James, Chris and myself, I'd like to thank you all for joining us in today's webinar.
Yes, thank you.
And the next slide, I'm going to put up the contact details for James and Chris. And please, by all means, contact both of them directly or via myself, and we can answer any further questions that you might have. So thank you for your time today.
Thank you, everyone.
Yeah, cheers, guys.